Hey, welcome to Real Estate Resource. Thanks for stopping by. Don't forget to like, subscribe, and hit that notification bell. I really hope you enjoy this video. So today, what I wanted to talk to you guys about is usually with standard forms for CAR is that new forms and updated forms come out every June and every December, and sometimes they throw some in November and January, but the most of the time, the majority of form revisions and new form releases come out June and December. So with that, we have some new forms and some revisions that are going to hit your ZipForms this month on June 20th, I believe is when they're going to come out. So I went through and the new forms for sure I wanted to show you, and I'm going to highlight some of the revisions on things that are more common for you guys that you'll kind of run across in your transactions. So real quick, any questions before I share my screen and we jump in? Anybody? Any questions about anything? Nope. All right. Well, let me share my screen here. Okay. So we're going to start with the new forms. So what you should be seeing is the use of non-standard forms advisory. Now, we're not going to read all of these things, but what this is it's for it's an advisory for your clients for forms that are created by the brokerage, right? So you guys have all been in a transaction where there's been some kind of broker created form that they ask you to sign, right? Like it's, some kind of disclosure, it's some kind of advisory, something that broker has created. It's not a standard form. It's not a CAR form. And sometimes we're required to sign these, especially if we're the buyer's agent, right? And we're getting them from the listing side. And the listing agent is, kind of forcefully requesting us to sign these things. We have to. But what this use of non-standard forms advisory basically says, as you see, there's nothing to fill out. It's just a signature by the client, right, that they've received it. Basically, what it's saying is this is not a standard form, and I, as your agent, I may not be able to explain it, which means I'm not responsible for the information that's contained within it because I'm not a lawyer, and I didn't create this form. CAR didn't create this form, so I have no knowledge of truly what it is or if it is at any way dangerous for you, right? Holds any consequences for you after the fact. So what it says is if you have to sign the standard form and you're concerned about the information that's contained in it, you should have it reviewed by an attorney. And that's basically what this is, right? It wasn't created by the Board of Realtors. It wasn't created by CAR. It wasn't created by CRMLS. And if that's the case, I can't give you advice on whether or not this is good or bad for you. Okay, pretty fair. I mean, it's straightforward. But that's one of the new forms that came out. I don't think that you have to include it with every transaction you do, but maybe if you're in one of those transactions where you find out that you've got some non-standard form, something provided by a listing agent, maybe you want to have this in your file and have it signed by your client. Okay. Any questions? No questions? All right. Let's move on to the next new one. And here it is. Hold on, let me get rid of this one. This is the Commercial Seller Property Questionnaire. So for those of you, the few of you that have done commercial deals, and I know that the majority of you and the majority of our transactions here in this office, and I don't know about those that watch the YouTube videos, are residential. Some of you are doing commercial, and in a commercial sale, there's different requirements for disclosures. So what CAR has done is that one of the things that a seller in a commercial transaction is supposed to provide is any known material facts about the same way a residential seller would have to disclose material facts that may affect the desirability of the property. A commercial seller still has to do the same thing, even though they're not the same level of required disclosures. So what CAR created here is a seller's property questionnaire, very similar to the seller's property questionnaire that we do for our residential sales, but it's about commercial. It's about the commercial property. So it is just that. It's just as we would do with a residential one. Are you, the seller, aware of? Yes or no, right? That's the awareness level. Are you aware of it? Yes or no? And you check yes. And if you check yes, you describe, you give a definition or an explanation of what that yes is, right? So these are this is all for commercial stuff, right? So you can see surveys and plans, permits, structural modifications, whether the property was built prior to 1994, the plumbing fixtures are compliant, right? So it's going to go through, have them ask the questions. Now, I don't see that this is a required form. This is just to allow the seller to kind of have a structured place to make those disclosures, the information that they know about the property, that they would have done kind of just through, drafted documents like amendments and addendums in the past for commercial property. So again, I think that it should be something that we're urged to use for our commercial sellers if we're doing a commercial transaction. But at this point, I don't think there is any level of requirement to it. It just would be easier. And ultimately what will happen, what usually happens with standard forms, is that even though the form itself is not required, but the information required in the form is, and now there is a specific form for conveying the information, it's going to kind of by default become required, if that makes sense, right? Because the information is required, right? So I could either handwrite an amendment or an addendum saying, hey, these are the things that I know, the material facts I know about this commercial property. I could do that and it would be acceptable. But as with most things, again, once CAR creates a form as a way to deliver the required information, that form usually becomes the de facto requirement for providing that info. Okay, is that fair? Questions from anybody? Again, I don't want to dig into these. They're not out yet. You're not using them. We will as we move forward, but I wanted you to be aware that these new forms that they exist and will be in your library for ZipForms on June 20th. Okay, so let's move on to the next brand new form, and this one in our office and probably for most residential real estate agents is going to be the most common new form that you're going to add to transactions, and that is the mixed use purchase addendum. So we see a lot of mixed use transactions here in the office, right, where you have some residential, some commercial part of it, right, where you have a couple units and you have maybe a storefront or a warehouse or a garage or something that is used for commercial purposes. And we have to kind of we have to pick or choose, right? We're doing either a residential income purchase agreement or a commercial residential income, right? We're moving things around and we're trying to make it fit. Well, what this does is it's going to now kind of clarify the mixed use aspect of this property. So you have, just like anything else, right? You have the property, the purchase agreement, the buyer, the seller. And now what it's going to do is a description of the mixed use property, how many residential and how many commercial units, and a description of the commercial units or space. So it's clarifying that information that we didn't have that clarity before. When we were writing offers on mixed use, we were using residential income or we were using commercial, and they both didn't kind of fit 100% for the property, right? Because 50% of it, or 75% of it was commercial and 25% was residential, or vice versa. And we didn't have that clarity in the offer because it wasn't addressing that other part, right? It was either addressing only the residential income, right? The couple of residential units that existed, but not really the commercial side of things. So what this is going to do is it's going to clarify that. So we're going to answer the questions, right? How many of these are residential units? How many of these are commercial units? The description of the commercial space, the tenant occupied, like if it's tenant occupied, if it's currently occupied, if they're going to be vacant, any of the additional financing terms that might be associated with it because it is a mixed use building, what's included with the sale, any additional allocation of costs, right, for environmental surveys and things like that that come with commercial transactions that aren't addressed with our residential income and other purchase agreements. any installation of some safety features, right? So sprinklers, fire extinguishers, hoses, things like that. Water conserving plumbing devices. It addresses all the surveys, the plans, the permits, any modifications that are going to be done, what income expenses or tenant estoppel statements are going to come, any changes during the escrow. So as you can see, it's going to address some things that were missing when we have these combo transactions that are residential and commercial, because in those transactions, we still have to kind of follow the rules, right? If it's residential, part of that's residential, we have to make the same disclosures and do the same things we would do if it was just residential units, but we also have to follow the commercial side of things. So it does help you balance it and maybe create some clarity. So those were the 3 new forms that I thought were going to be really important for you. Actually, you know what? I left one out. I almost skipped one of the new ones, and that is this one. So let me share this one with you. This one's, again, another real short one. It is the Fair Appraisal Act Addendum. So starting July 1st, there is a new law that they're changing. They're changing some terms for discrimination, right? Like, so we had that fair housing advisory that comes with your offer. This is adding to that about the appraisal, that the appraisal of the property is required to be unbiased, objective, and not influenced by improper legal considerations, including but not limited to any of the following: race, color, religion, including religious dress, grooming practices for both, gender expression, sexual orientation, marital status, medical condition, military veteran, national origin. So what they're trying to kind of get across here is that your appraisal is only based on the property, and there's no swaying it based on maybe an idea that someone has, like, hey, we're selling to somebody who's a specific race or a specific religion or identifies as a specific gender. So, we're going to skew the appraisal because of those things. So what happened is because this change to the civil code showed up, instead of readdressing the entire contract or to that paragraph, they've just added into the purchase agreements a little box that's checked that includes this addendum to all the purchase agreements. So you'll see it in the RIPA, you'll see it in the regular RPA, you'll see it in the NODPA. All of the purchase agreements are going to now reflect, and those are really the only changes that happened to the RPA for this June change, was adding this section. Laura, did you have a question? I saw you unmuted. It was an accident, I guess. Okay, so that is the last new form I wanted to show you. But just so you guys know, it looks like it'll be attached to every purchase agreement, because I think by default that box is going to be checked on your purchase agreement. So just like when your agency disclosure shows up and all those other forms, the PRBS, that automatically come with it, I believe that this is going to be another one of those that just come automatically attached with your offers. Okay, so now let's look at some of the changes. And the first one I want to show you is the cancellation of contract. So just so you guys know, the red sections, these redlining sections that are showing up in these drafts, because these are, if you see, it says draft across there because they're not available forms yet. Those red sections are the changes that have been made from the previous version of this form. So with this cancellation of contract, I have to look, whether it's coincidence or not, I want to give credit to our very own Tony Pedroza for the changes that happened in this contract, or in this document. So a few months ago, I think it was probably February, Tony had a transaction that unfortunately was canceling, right? He was representing the buyer, and they hadn't yet put the deposit into escrow. So to complete the second half of the cancellation, it's the disposition of the deposit, right? When you cancel the escrow, we've all seen that. But there was no deposit. He didn't know what to check, right? He didn't know which section in the second paragraph to check off to complete the cancellation, because there was no deposit that needed to be, considered with the cancellation of the escrow. So he called the CAR hotline. He called the CAR hotline, and the attorney on the CAR hotline was stumped, just as he was. They said, "Well, I don't know what to check. There should be something here. We need to have something that references that there is no deposit that is affected by this cancellation." And the attorney said, "I have to go check with somebody on what to do because it doesn't exist." And when the attorney got back on, they came up with a solution, which was to put, buyer agrees to release X amount of deposit, and they put a 0 in that section. And then the attorney said, "You should call CAR and tell them you should send an email. I'm going to send an email since I work for CAR and say this needs to be fixed." And in this revision of the cancellation, it was fixed. So I don't know if it's a coincidence, but I want to at least give him some credit to say that because he had posed this question about how to fill out the cancellation correctly, it was adjusted by CAR just a few months after his transaction. So let's give him credit. Whether or not that came with some other agents that made complaints, let's give Tony Pedroza credit. So when you see him, give him a pat on the back because he did something to help you guys out. So let's look at the changes, okay? So in accordance with the terms and conditions of the purchase agreement, right, that's normal. It has the agreement when it's dated, including all amendments and related documents on property known as. So it never said that before. It just said, hey, we're basing it just on this one purchase agreement, but we make all kinds of amendments and addendums, and there's other forms that come in. So they wanted to bring them in and say, hey, based on everything we've all signed, we are now canceling, right? This is what the cancellation is. So buyer's name, seller's name. Now they've split this up, right? Both paragraphs 1 and 2 below constitute escrow instructions to escrow holder. Number paragraph 1, cancellation of contract. A, one-party cancellation. This paragraph is used to cancel the agreement by buyer or seller. Its terms apply whether or not both parties agree to disposition of the deposit and cancellation of escrow in paragraph 2. So what it's saying is this first section, right, paragraph 1, A and B, is about the transaction. So we have to be able to separate the two. I'm canceling a transaction and I'm also canceling an escrow. Those are the two things I'm doing. We kind of look at them as one, where we say, okay, well, I'm canceling the escrow. Okay, but we're doing two things when we send a cancellation. We're canceling the contract, right? Because whether or not I have an open escrow doesn't matter to the contract. So when we're talking about the CAR forms, we're talking about an RPA. Once I have my RPA accepted, whether that seller opens escrow a day later or a month later, I still have an accepted contract. Okay, the escrow is separate. So this form, this document, the cancellation of contract, is doing two things. It's canceling my contract and it's canceling my escrow. Okay, so this first section here is about canceling the contract. So paragraph 1A is who is canceling, the buyer or the seller. Okay? And why are they canceling? As permitted by good faith exercise of a paragraph? Are they doing it because of a contingency, because of the loan contingency, the appraisal contingency, the inspections and investigations, the disclosures? What paragraph are they canceling for? That's what that's for. If the seller is canceling and they check this box, it's because the seller sent a notice to buyer to perform and the buyer failed to perform, so now the seller is canceling. If on the reverse, the buyer sent a notice to perform to the seller, and they're the one that's canceling, they're canceling because the seller failed to do what they were supposed to do based on the notice to seller to perform. And the last one is whichever party was delivered a demand to close escrow and failed to close escrow, right? That's the choices. Or another, right? It could be other, which is whatever the terms are that you've decided to cancel for, and that's endless and numerous that you could write in there. And the thing that they added here in 1B is a proposed mutual cancellation. The buyer or seller signing below proposes a mutual cancellation of the agreement. The cancellation is only effective if the agreement is reached by both parties signed in paragraph 2 below. Okay? So what we're saying is, hey, we both agreed we're okay with canceling, and that's what we're going to check that box for. Okay? Now we get down to paragraph 2. Paragraph 2 is the cancellation of the escrow and the disposition of the deposit. Okay, so it even says here in bold, Purpose of paragraph 2. This paragraph is used to instruct escrow holder to cancel the escrow for the purchase or sale of other designated transaction for the property and what to do with the deposit. Any cancellation of contract pursuant to paragraph 1A remains in effect even if both parties to the agreement do not sign below. So if we go back to 1A, we're not talking about 1B, we're talking about 1A. Any of these terms up here, right, which give you the option to cancel, they're saying that no matter what happens, if I don't sign paragraph 2, paragraph 1A is still in effect, which means I've canceled the contract. We may not have canceled the escrow, but we've canceled the contract. My responsibility to follow the terms of the contract no longer exists. That is canceled. Now all we're doing down here is negotiating the escrow. Okay? Release of funds are not automatic. Release of funds by escrow holder pursuant to paragraph 2 requires mutual signed release instructions from buyer and seller, judicial decision or arbitration award. So what that means is either we both sign and give this to escrow and escrow says, yes, here we go, and they may generate their own escrow instructions for the release of deposit, or we've gone to court, right? We've gone to court. We have a judicial decision or an arbitration award. Then the court can instruct the escrow whether the seller and buyer have both signed. The court can instruct the escrow to release a deposit to one party or the other. Okay? A party may be subject to a civil penalty of up to $1,000 for refusal to sign such instructions if no good faith dispute exists as to who is entitled to the deposited funds. What that means is, for example, if let's say the seller sends a demand to close escrow to the buyer. The buyer fails to close escrow based on the terms of the demand. The buyer has removed all of their contingencies. All of them are gone. And the seller requests the buyer to release the deposit. The buyer refuses to sign, which means they either have to go to small claims or mediation, whatever it is. They have to get somebody to intervene and direct for those funds to be released to that party. If the court or the mediator finds or the arbitrator finds that there was no good faith reason for the buyer to not release their deposit to the seller when they were supposed to, they could enforce an additional $1,000 civil penalty on top of the money being released. So not only would the buyer lose their deposit, but they may have to come out of their pocket $1,000 on top of it because they weren't following the terms of the contract. So that's what that means. Okay. So now here's the ways that the deposit can be released. A full release and disposition of the deposit. Select one of the options in C or D, but not both, right? You can only accept one of the options, okay? So we're going to go through those options. Both buyer and seller cancel escrow number with the escrow holder, right? So whatever your escrow number is going to go here. Whoever the escrow holder is going to go there, right? So if it's, whatever the escrow number is in Pacific Escrow goes here. The parties mutually release each other from any obligation to buy, sell, or exchange the property under the agreement. Mutually release each other from all of their claims, actions, and demands that each may have against the other by reason of the agreement, and intend that all of the rights and obligations arising from agreement are null and void, right? So we're just saying we're canceling everything. We don't have any kind of connection to each other any longer. Now, here's the choices. Number 1, seller authorizes release of buyer's deposit to buyer, less buyer's fees and costs already incurred and agreed to in contract to be paid through escrow, including any escrow cancellation fees, right? So any fees that the buyer was supposed to pay are going to get charged from their deposit, even though seller is giving it back to them, okay? Number 2, buyer authorizes release of buyer's deposit to seller, less seller's fees and costs already incurred, and agreed in the contract to be paid through escrow, including any escrow cancellation fees. Or this little box here that you have in parentheses, pursuant to a properly executed liquidated damages clause, buyer's authorization to release of deposit to seller is limited to no more than 3% of the purchase price. If the property is a dwelling with no more than 4 units, one of which buyer intends to occupy, any additional deposit shall be returned to buyer. So what it's saying there is it's kind of breaking it down, and you're going to want to check this off. If you're ever releasing your deposit as a buyer to the seller, you're going to want to check off this box, because we all initial the liquidated damages clause in the RPA. So what that means is, let's, for example, say that we have a sales price of $500,000, which if you can find me one, let's buy two, right? We find a sales price of $500,000. Our deposit is $20,000. The total deposit I put in escrow is $20,000. But we signed a liquidated damages clause. We initialed it, and so did the seller, which means that my loss of my deposit, liquidated damages, is limited to 3% of the purchase price. 3% of $500,000 is $15,000. That means the most I could lose from the money that was deposited in escrow is $15,000. Anything over that $15,000 has to be released to me. So if for whatever reason your buyer is canceled, they acted in bad faith, they have to give up their deposit, and you've initialed a liquidated damages clause, and you have more than the 3% in there, please make sure that you check this box. Okay, so that they get the rest of their money back. The third choice, buyer authorizes release of blank amount. Right now, a lot of times we negotiate with the seller and say, hey, I have $10,000 there, but we'll give you $5,000 if you'll let us cancel, right? So you put that negotiated amount in there so that they know that that's what you're going to release. Everything else gets returned to you, to the buyer, okay? And the very last one is what we can thank Tony for. There is no deposit in escrow. Each party to pay their own unpaid contractual fees and costs, if there are any, already incurred and agreed to in the contract and paid through escrow. There is no, at that point, usually there is no cancellation fees, because if there is no deposit, there is no escrow instruction signed, which means that escrow probably isn't going to charge them any cancellation instructions because they've done a cancellation fee because they've done no work really on the transaction. So there's probably not going to be any fees to be paid, but don't worry about that. Just, this is what we do now. There is no deposit in escrow. So if you guys ever have a cancellation prior to you depositing the funds in escrow, that's the box you're going to check, and we're going to move on. Questions so far?
Question.
Yes.
What if the seller cancels and the buyer has already paid things like an appraisal? Which one do we pick for that?
You don't, because your buyer is responsible for those fees. Nobody else is.
Even if it's the seller who cancels on
the seller can only cancel if the seller has the right to cancel, which would mean either the buyer isn't performing or the seller had some kind of contingency, right? Contingency of finding a replacement property. So if the seller is canceling because the buyer doesn't perform, the buyer doesn't get rewarded for that, which means they're not getting their fees paid for. You guys, when you talk to your buyers, you should be letting them know that, hey, by the way, you're going to pay X amount for an appraisal and X amount for an inspection. And if you don't perform and the seller cancels on you, or you allow the seller to cancel on you when they don't have the right to, or you choose not to move forward because of the condition or because the property doesn't appraise, you're not getting that money back. That $1,000, that $1,200 that you paid, that's being paid and you're not getting it back. Now, if the seller is trying to cancel and they don't have the right to, and you're negotiating with them, you can ask for the seller to pay for that stuff, but they have no obligation to do that.
Got it. Okay. So my scenario would never really occur. Got it. Thanks.
It happens sometimes. The seller's canceling and they don't have the right to, and they say, okay, well, if you let us cancel so we could just move on with our life, we'll pay you back for your appraisal. But it doesn't, it's not common. It's not common.
Got it. Thank you.
Mm-hmm. Okay. Partial release. This is D, right? We can't have C, 1, 2, 3, or 4, and anything in D. It's either one or the other. So D is a partial release and reservation of rights. Buyer and seller cancel escrow number blank with the escrow holder. The parties mutually release each other from any obligation to buy, sell, or exchange the property under the agreement. Reserve all rights to retain any obligations they have towards each other under the agreement, except for the obligation is applicable to buy, sell, or exchange the property, and authorize escrow holder or blank to hold any deposit until receiving subsequent mutual instructions, judicial decision, or arbitration award. What that means is this. Hey, listen, we want to cancel. We want to be able to sell the property. We want to move on. We don't want to have this escrow hanging over our head. Cancel the escrow, but hold on to the money until you get instructions on what to do with it so everybody can go their own way. That's really what's happening there, okay? I mean, I don't think that that's ever going to be an option for anybody, because for a buyer who doesn't want to release their deposit, the idea that I'm letting the seller go and that means they can go sell it, open a new escrow, close that escrow, do all that stuff, they don't have any motivation to ever really kind of hash out what's going to happen with the deposit. They could sit on it forever. So, I mean, that's not always going to be a choice, but it may be. There may be some kind of reasoning behind choosing that. The last one in bold, scope of broker duty. Agents are not qualified to provide any opinion on who is entitled to the deposited funds or whether a cancellation was made in good faith. Buyer and seller are advised to seek the advice of a qualified California real estate attorney regarding this matter. So what it's saying there is like, hey, we know the contract and it says you should, but I don't know if there's some kind of other legal issue, loophole, or finding that is going to cause the other party to have the right to do what they're doing. And when it comes to stuff like that, we should say, hey, listen, based on the contract, this is what should happen. But once we get into the legal arena, and this is, I've told you guys this in the past, if I go to small claims court, even if the contract is 100% on my side, but I get to small claims court and I stand in front of that small claims court judge, that judge is a human being, and that judge does not know real estate law, and that judge really doesn't care about the contract a lot of times. Some of them do. Some of them are like, hey, contract says, give them the money and it's over. Others are going to have opinions, and you may say the wrong thing to this small claims court judge, and he may rule against you even if you're in the right. So what I always say to you guys is small claims is a coin toss, right? It's 50-50. You don't know what you're going to get. You can't walk into small claims court and we're going to win. It's happened to us in the past where we believe 100% we're going to win. And we kind of won, but we didn't 100% win, right? Like things that sellers have done that we felt was egregious. And the court says, yeah, well, but you kind of knew. They don't owe you everything. We'll give you a little bit, but not all of it. You know, so keep in mind, and that's what this is referencing, is that I'm not an attorney. So all I can do is give you an opinion about what your rights are based on this contract. But once we get out there into court, into mediation, into arbitration, things could change because there are different opinions that people have. Maybe a mediator or an arbitrator has seen so many cases like this that they have a different view on whether or not there was a breach of contract. And we can't change that once we get out there. So what we do is if there's any concern that you have, like we have to tell them, hey, I don't know what's going to happen. It's 50-50 at best if we fight for it. Even though the contract says once we get out there, it's 50-50. So if you want to talk to a real estate attorney to see what your real chances are, or what their opinion of our fight will be on the outside of this, then please do that. But all I can tell you is contractually, this is what the contract says. Out there, I don't know because I'm not an attorney. Okay? So that's why we have to be really careful when we're giving advice. You know, I get questions a lot about taxes and things like that from agents. And we can give them the broad strokes of how taxes work, right? Like how capital gains work and how a 1031 works, but we're not experts in those things. So we can give them the broad strokes, but then we have to refer them to an expert to help them with those issues. Same way with this. I can give you the broad strokes of what the contract says. I can't tell you what a judge or an arbitrator is going to find. Once we get to that level, maybe an attorney will have a better view of that. You need to consult one if you have concerns. All right, any questions about the cancellation? No, all right. So let's move on. So they made some changes here to the manufactured home listing. I typed that wrong. Listing addendum. Manufactured home listing addendum is going to be revised. All of this red stuff is the change. So anything that you see written in red has been added to the addendum. And going through it, and what I see is it just clarified things a little bit more. It broke it up. So you have manufactured home on rented land, manufactured home to be sold with real property, right? And a real property manufactured home. Those are two separate things. Right? There is a mobile home that you're selling with a plot of land, which is really kind of kind of attacked as it would be a vacant land, and it has the breakdown here of how much the value of the manufactured home is and how much the value is of the actual real property. And then they have a real property manufactured home, which means that that manufactured home has a building permit, has a foundation. It was built like a normal house on that piece of vacant land. So now the APN number actually reflects that it's a home. Okay, so all of these things, right? It says here, real property managed home is one that meets the following requirements. A building permit is obtained from local authorities pursuant to health and safety code. The manufactured home is affixed to a foundation pursuant to health and safety codes. A certificate of occupancy is issued by local authorities, and there is recordation with the local authorities of a form pursuant to health and safety code. So it's like a real house. Right, that's what they're saying with this one. This one is just, hey, there's a piece of vacant land with a mobile home on it. They're two separate things. And then the first one here is, like normal, the manufactured home or mobile home that we call them, is in a mobile home park. There is a space lease, and there is a manufactured home that is in that space. Okay. There's some references down here to the descriptions, right? So you have the manufacturer's name, the model number, the date of manufacture, the first sale, if the property is on the tax roll, or if it's part of the HCD, the Housing and Community Development, which is what most of the mobile homes are that we're dealing with, are manufactured homes. And those are things that if you have questions about manufactured home specific and how that part works, you could talk to Yali in Pacific Escrow. She does the manufactured homes there, and she'll be able to tell you how that registration with the HCD works. Okay. There's the license numbers, the serial numbers, everything for the property. Items included, right? It's what's included unless otherwise specified in the purchase agreement. All fixtures and fittings, just like with a regular house. Okay. These things were added, but it's all the same stuff that we've had before in regular purchase agreements, but it's just specific to the manufactured home, which is, hey, you're going to have no liens or encumbrances recorded against it. You're going to give us a certificate of ownership. You're going to submit the lease rental agreements with the park. All of those things are referenced here. And then we just have the signatures. So this is just part of the listing addendum, right? So if I take a listing agreement, this is going to go, I'm going to use a regular residential listing agreement, and I'm just going to attach this to it, which is going to break down the details of that manufactured home that you can't reference in a regular residential listing agreement. Okay, questions? Any questions? Okay. Let's go next to then the probate agreement purchase addendum. They just changed in here the type of probates, the information that's here. They've added, if you look at the red, if the property is being sold as part of a decedent's estate, paragraph 3A applies unless 3B is checked. So 3A, what they're saying is, by default, the court confirmation is undetermined at the time of the offer. 3B is only if you check if you know that it needs a court confirmation for the purchase agreement. So they added in here that the default is 3A. If the property is being sold through conservatorship or guardianship or receivership, then court confirmation is required and the sale shall proceed under paragraph 3B. If the type of probate is incorrectly identified in paragraph 1A, seller shall inform buyer of the correct type of probate sale no later than the time for seller disclosures in the agreement. Okay. This is about the court confirmation stuff, right? When they're going to give it to you, if they're going to tell you it's at acceptance, whether or not, or within the time specified for delivery. So if we don't know that there's a court confirmation required, there's two choices. They can either tell us at acceptance or when they deliver all of the disclosures to us. Okay. If court confirmation is not initially required, notice of the terms of sale to beneficiary heirs is still necessary. If any beneficiary heir objects, then court confirmation shall be required. Seller shall promptly deliver written notice to buyer once seller has notice of any objection by a beneficiary or heir. If seller notifies buyer that the court confirmation is initially determined to be required or court confirmation becomes required as a result of an objection to terms of sale by a beneficiary or heir, then buyer within 3 days after delivery of seller's notice may cancel the agreement and shall be entitled to return of any deposit paid. If court confirmation is or becomes required and buyer has not canceled pursuant to paragraph 3A, then the sale shall proceed under paragraph 3A. 3B. So they've added in there that, hey, listen, if you tell me later, if we don't know that there's a court confirmation, or at the time right now there is no court confirmation required, but later because of the circumstances change, like a beneficiary heir says, no, I don't like the terms of this one, and we have to go to court confirmation, when they give me the notice of court confirmation, I have 3 days to cancel as buyer. If I don't cancel in those 3 days, then I have to continue on with the contract as if we had checked off paragraph 3B, which means we're going to go through the court confirmation process. Okay. All these things are the same, and that was the only change to that one. So I wanted to show you because, again, it's one of the ones that we use often for probates. And let's see where we have here. Oh, quickly. The fire hardening has added a bunch of stuff, and we just talked about this fire hardening defensible space disclosure not too long ago, because it's one of the ones that is like starting to pop up as an issue. So I'm not going to read all of what's in the red, but what it does is it's just saying it's really enforcing when it's required and when it's not, because I think that what's happening is that agents don't understand it. So buyer's agents are really going hard after the listing agent and requiring this form to be included even when it's not necessary. So what this first paragraph 1 is saying is, listen, if all 4 conditions of providing this disclosure are not met, which are the home requires a TDS, right? That's 1. Number 2, in your NHD report, it said that the property is in a high or very high fire zone, okay? And it is a residential property that's 1 to 4 units, right? So if it's 5 units, you don't need to do it. So there's 3. And the 4th one is hold on, properties located at, where'd it go? Notice of disclosure, are only required. Residential properties, if the property contains 1 to 4 units, the seller is required to complete a TDS. The property is located in a higher, very high, and the improvements on the property were constructed before January 1st, 2010. That's right. So if the house was built before 2010, if the property is 1 to 4 units, if they're required to provide a TDS to you, and if it's in a high or very high fire zone. If not all 4 of those things are met, then I don't have to provide this form. Okay? So it has to be all 4 of them. And I think that's why they did this. They've added this whole paragraph that's just about, hey, this is not required. It's only required if, okay? And then this is answering questions, right? So if it's required to give, right, we hit all 4 of the conditions, it's required for us to answer these questions as the seller. Fire hardening, are you, the seller, aware of the following features that make the home vulnerable to wildfire and flying embers? Now, are you, the seller, aware? Just like any other disclosure that we have, are you aware? If you're not aware, then the answer is no. Eave, soffit, roof ventilation, the vents and openings in excess of 1/8 of an inch or are not flame or ember resistant. Do I know that? The answer is either yes or no. Are you aware of that? No, I'm not aware of it. Then you check no. Roof coverings made of untreated wood shingles or shakes. Do I know it? If I know that, then yes. If I don't, then no. Combustible landscaping or other materials within 5 feet of the home under the footprint of any attached deck. I don't know. Am I aware of that? Yes or no? So that's just the way I'm going to answer those questions, right? This whole defensible space disclosure and addendum is added, right? So this paragraph 3 is only required to be completed if all 3 conditions in paragraph 1B are met, which is this one. The disclosure and requirements specified in paragraph 3 are only required for sellers of residential properties. If the property contains 1 to 4 units, the seller is required to complete a TDS, and the property is located in either high or very high hazard severity zone. If any of these 3 conditions are not met, paragraph 3 doesn't work. And so, right, we get down to paragraph 3, we don't have to fill this out if it doesn't match those 3 things. Okay, but these are just, again, local compliance required. The property is or is not subject to a local vegetation management ordinance. If the sellers know that, then you're going to check yes, it is or it isn't. Right? And they should know that if they're in that area. Seller representation of property compliance with the applicable state defensible space requirement or local vegetation management ordinance, hereafter state or local defensible space law, at the time of the seller's signature. Seller is unaware of whether the property is in compliance with the applicable state or local defensible space law. Seller does not have a report prepared by an authorized defensible space inspector. If you don't have it, you don't have it. Or the property is in compliance with the state or local defensible space law, whichever is applicable. If state law applies, seller must have obtained compliance within the last 6 months. Seller shall deliver buyer documentation of compliance within 3 days after seller's execution of the FHDS form or the time specified in 3N1 of the purchase agreement. Okay? Whichever occurs last. It is this if this paragraph is checked, also check paragraph 3C5 below. We'll get to that in a minute. Or 3, property is not in compliance with state or local defensible space law, whichever is applicable. If seller has or agrees to obtain a report prepared by an authorized defensible space inspector, seller shall deliver such report, right? So I haven't even agreed to give you the report yet, but it's not in compliance. So let me get to 3C, buyer and seller agreement regarding which party shall obtain compliance with applicable state or local defense space requirements. Buyer responsibility. Buyers shall obtain documentation of compliance within the state defensible space law within 1 year of close of escrow. If I check this box, buyer responsibility, right? Local vegetation management. We could check it off, or we could choose, right? We can negotiate. Is it the buyer that's going to be responsible for this stuff, or the seller? And then if you know which local agency it is, you have to put the information in here. This final inspection report and disclosure, seller has obtained a final inspection report. That's if you've gotten it from the state or city, whoever's doing the ordinance, okay? So that was the changes to that. We just went over it a couple weeks ago, and now they've made changes to it. So, again, you only have to use this form if, in your NHD report, it says you're in a high or very high fire zone. You have to provide a TDS as part of your disclosures. It's 1 to 4 units, and it was built before 2010. If it doesn't meet any of those 4 things, if it only meets 1 of them, you don't have to do it. If it meets 3 of them, you don't have to do it. So keep in mind, you don't have to provide unless it's all 4. Okay? Patricia, you had your hand up. Did you have a question?
You answered it when you said all 4 or nothing.
Yeah. Yeah, it's all 4 or nothing. Okay? All right. And let me see real quick. Let me jump into this. There's a couple more. The SPQ, come here, open up. What I wanted to show you on the SPQ is just this. So we all know that we have to disclose whether or not an occupant died on the property within the last 3 years. Okay. Now what they've added, within the last 3 years, the death of an occupant on the property, upon the property, yes or no, right? The death of, yes or no. Note to seller, the manner of death may be a material fact to buyer and should be disclosed, except for death by HIV or AIDS, right? Because they don't want that to be a discriminatory thing. It never used to say that. The only time we were required to disclose the manner of death is if it was a violent death, right? Meaning somebody was murdered or somebody committed suicide. Those were the only times we were required to disclose it. If the buyer asked how they died, we were required to respond, right? Answer the question. Now they're saying you need to disclose. How did the person die? They died of old age, they died of cancer, they drowned, whatever it is. You have to disclose how they died when you make the disclosure. So when you check off the box that says yes, not only do you have to explain who died, but how they died when you answer that yes question. That got added to the SPQ, so I wanted to prepare you guys that that's something that you're going to have to do now, okay? Because when you guys get the print version of this, the actual working version on June 20th, that's not going to be in red. It's going to be in black and white. And I know how selectively we read things, ourselves and our sellers and buyers, right? So I wanted you guys to all be aware of that. Let me see. Is there anything else I want to show you guys that I think is important? Let me see. Yeah, Fred, it's only within 3 years. Now, if somebody asks you about outside of the 3 years, then you still have to disclose it. Okay, Patricia, you have your hand up again. Go for it.
So I understand this is the level of detail for the SPQ, but for the MLS,
no.
Do I need to put it on the MLS?
No.
I just need to put death on property.
No, you don't need to put. You don't even put that on the MLS. You don't need to put that on the MLS at all.
So I question that because I could get all the way through on a transaction up to the SPQ, and then once they see that, they back out.
Yeah. Okay, that's what happens most of the
Mm.
time. But you're talking about 7 days into a transaction. You're not talking about 3 weeks into a transaction unless you're not providing your SPQ in a timely manner. But if you want to put it in the MLS, go ahead. But you're not required to. I
Okay.
wouldn't.
Okay. Thank you.
All right. So this is a pretty new form, right? The TOPA that I just wanted to bring it up. There's some changes to it, and it's just one thing, right? The TOPA comes with that rent cap and just cause addendum, right? It comes attached with it. They just added this paragraph here that just says it's just here to tell you it's an advisory. It's not something that has to be filled out, or it doesn't mean it's in effect. It just comes with the form, and it's an advisory. But I wanted to talk about the TOPA just real quick since we had a couple minutes before we finish. If you're writing an offer with tenants, whether those tenants are going to stay or are going to vacate at the close of escrow, this has to be included in your offer. Okay? This is not about, oh, this is only for tenants staying or this is only for tenants being evicted. No. Tenants leaving, tenants staying, this has to be incorporated into your purchase agreement. I just wanted to kind of drive that home. But the changes on here are very minimal. It was just that again to kind of reassure the buyers in that RCJC, because I know people see that RCJC and they're like, what is it? It's just an advisory that just says, hey, listen, there's some rules in California about how much you can raise rent and how often and how you can evict people, and that's basically all it is. Okay. All right, so great. We got through those things. Did you guys have any other questions before I let everyone go and enjoy the rest of their day and all of those things? Anybody have any questions? All right, terrific. I really appreciate you guys being here. I'm always happy to help you learn and be better, more professional realtors, and I hope I do that. So thank you guys for spending that hour with me, and I hope you guys have a healthy and productive day. Take care of yourselves.